Thank you so much for joining us here on Atlanta News First Plus. From the First Alert Desk, we are taking you out to a live look inside of a courtroom where more than 60 people, as we speak, are being arraigned on RICO charges in connection to protests of the Atlanta Public Safety Training Center, also known as Cop City, as these activists have described it. Now, I'm going to take you out full screen to this courtroom here. This is something we've been following since about 9:30 this morning, a little after 9 when court got in session. Again, more than 60 people, 61 to be exact, are being arraigned on organized crime charges relating to their efforts, as prosecutors have described, to stop the construction of the controversial Atlanta Public Safety Training Center. Now, this is taking you inside of a Fulton County courthouse. It's been a heavy issue for Atlanta residents, for a lot of demonstrators, some out of state that have come out this way to oppose the development of this public safety training center that's supposed to house emergency training, police, and other law enforcement efforts and first response efforts in the city. It's a big project involving really a heavy amount of taxpayer dollars, a lot of legislative involvement over the past couple years that this project has been getting underway. And a big contention has been the opposition, both environmental and political, from some individuals who call themselves Cop City protesters, or are part of the Stop Cop City movement, opposing the development of the Atlanta Public Safety Training Center. Let's listen in.
Right. And it doesn't appear that your client has surrendered at this point.
No, Your Honor. We did have, it's my understanding that there was a consent bond with prior counsel to submit that. I'm assuming that we will still be able to submit that. I just changed it with my name on it. So we'll be submitting that, Your Honor.
Today?
Today, yes, Your Honor.
Right.
Yes. Yes.
And Mr. Warren, are you aware of the charge pending against you?
Yes, Your Honor.
Are you represented by Mr. Allencar?
Yes, Your Honor.
All right, counsel, you waiving formal arraignment?
Yes, Your Honor.
And it appears that your client has not yet surrendered?
That's correct, Judge. We've submitted a consent bond to Ms. Bell. I do have a hard copy if the court would want me to submit that as well.
Do you need it, Ms. Bell?
Yes, I need it.
All right, you can step up and
Thank you.
pass it to her. Last, Ms. Wasilewski, is that correct?
Yes.
All right. Are you aware of the charge pending against you?
Yes, Your Honor.
Have you been interviewed by the Public Defender's Office, or do you have counsel?
I do not have counsel. I've been approved for a public defender, but I've not been here yet and I've not been interviewed.
All right. So that would likely come through the Conflict Defender's Office, Ms. Harrison?
Yes, Judge, is that Sarah Walowinski?
It is.
Oh, I apologize.
Wasilewski.
Wasilewski.
Say it one more time.
Washaleski.
Wasilewski.
Wasilewski. And Judge, we have approved a conflict defender in that case.
All right. So, Mr. Regis, do you want to step down for a moment?
Excuse me. I'm sorry. Excuse me.
Are you waiving formal arraignment?
We are, Your Honor.
And since you and Ms. Walker are both here, I don't know if I'll ever have that again. How long do you all anticipate it will take for counsel to be appointed?
Before the end of the week, Your Honor.
Thank you. I think that's what you told me over the weekend.
Yes, Your Honor.
Thank you. All right. It appears that Ms.
Washaleski.
Wasilewski has not yet surrendered on the charges.
I intend to surrender within the next 24 hours.
All right. And do you intend to post the $50,000 bond? That's
I have a consent bond that I intend to submit.
all right.
Discussing with counsel.
All right. Have you arranged all of the details of that been worked out, or?
Not yet, no.
All right. So then that needs to happen to Mr. Regis. Mr. Regis,
I'm sorry, Your Honor. The state has indicated they have consented to what has been previously discussed, and we'll be submitting that immediately after Ms. Wasilewski proceeds. So,
that's pretty good. You got it. I think that's what it is, Wasilewski. Is that right?
Yep. Good
I guess if we say it enough, we'll get it. All right. If you will do that, Ms. Regis, so that we can deal with the issue of bond. All right. For each of you, I am further noticing your case to the courts, to a final plea calendar of this court to occur not later than June 30th of 2024. The date will represent your last opportunity to tender negotiated pleas if you wish to do so. None of you has to plead guilty. If it is your desire to maintain your innocence and have your cases moved along to trial, the court is happy to do so, but I will not accept a negotiated plea after the final plea hearing date the court will provide. I simply need to make sure that you all understand. I also want to make sure that each of you understands, to the extent that you have not surrendered on these charges to the custody of the Fulton County Sheriff, that you must do so within 24 hours or not later than 10 a.m. tomorrow morning. I think the consent bonds have been either agreed to or are in the process of being submitted for each of you, but you'll need to make sure that in any event you still surrender. Ms. Tilbury, any questions regarding next steps?
No.
Mrs. Malova, any questions on her behalf?
No, Your Honor.
The state?
Packet has been provided to counsel, nothing further from the state.
I have received it. Thank you.
Thank you. Mr. Vassell, any questions regarding next steps? All right. Let's see. Mr. Foster, any questions on his behalf?
Your Honor, I hadn't asked about bond.
I did not.
But Ms. Vassell turned in yesterday. You processed that order? Yeah.
You turned yourself in this morning?
I turned myself in yesterday.
Yesterday, and you were processed out when?
I was processed out in the evening.
I'm sorry?
In the evening yesterday.
Yesterday evening, so it was all on November 5th. Thank you. Maybe I knew that, Mr. Foster, which is why I didn't ask. No, that's okay. Anything else?
No, Your Honor.
All right. Anything else on behalf of the state?
Just to hand the packet over. Other than that, nothing further from the state.
Mr. Zen? Any questions regarding next steps?
No, Judge.
Mr. Regas, it does not appear that Mr. Zen has surrendered. And if he has, I don't have that information. Do you know?
No, I surrendered on the 4th.
And when were you bonded out?
Yeah. Actually, no. Because when I got out, it was on 12/30, so I think that I started on the 3rd and I was out on the 4th.
So Friday to Saturday.
Yes, Judge.
All right. Anything else on his behalf, Mr. Regas?
Nothing, Your Honor.
The state?
Nothing further from the state, Your Honor. The packet's been provided to Mr. Regas.
Thank you.
And Mr. Voiso has elected to retain possession of his copy of the packet, Your Honor.
All right. Mr. Zen, you'll be responsible for ensuring that the lawyer who is ultimately appointed to represent you after you interview with the Public Defender's Office receives that information. Do you understand?
Yes, Judge.
All right. And both you and Mr. Vassell will need to ensure that you are interviewed by the investigators from the Public Defender's Office before you are excused. Understood?
Yes, Judge.
All right. And they're both in the back. All right. Mr. Ward, any questions regarding next steps?
No, Your Honor.
Anything on your client's behalf, Mr. Thompson?
No, Your Honor, and we have received the state's packet.
All right. The state?
Nothing further from the state, Your Honor.
All right. Mr. Warren, any questions regarding next steps?
No, Your Honor.
Anything on your client's behalf, Mr. Alper?
No, Your Honor, we have the packet.
All right. Mr. Fowler?
Nothing further from the state, Your Honor.
And Ms. Washaleski, any questions regarding next steps? Anything on her behalf, Mr. Regas?
Nothing, Your Honor. And again, Ms. Washaleski has elected to retain possession of her copy of the packet from the state.
You'll need to make sure that you provide that information to whoever is ultimately appointed to represent you.
Yes.
All right? If there's nothing more, you all may be excused with the exception of those who need to be interviewed by the Public Defender's Office, and please leave those green cards in the back as you're leaving. I'll see you back when you're noticed by the court or directed to report back by your attorneys. Thank you.
Thank you.
What about the two in custody?
And Judge, I do have some updates about people who've qualified whenever the court is ready.
Give me just a moment. I'm ready for Miss English and Miss Meissner, please. I need their numbers. I'll try to look for them. I don't see her. I don't see anybody with that.
Yep, y'all have said it.
Do you have the numbers? I don't see them. I see Miss Meissner, but I don't see anyone For the All right, for the two of you, starting with Ms. Bogish, are you aware of the charges pending against you?
Yes, Your Honor.
All right, and you'll have to speak up so the court is able to hear you.
Yes, Your Honor.
All right, Mr. Bennett, are you representing them both?
I am, Your Honor.
And you will be filing a conflict notice?
Yes, Your Honor.
A
They
waiver
were
of
executed.
conflict?
Yes, Your Honor.
Are you waiving formal arraignment?
We are, Your Honor.
All right. And was there a consent bond entered in their case?
Consent bond motion was filed October 23rd, and order was attached. I believe that because they've already been booked in, we may need to restyle it as a consent motion to reduce bond. So I'm prepared with a Word doc to forward to Ms. Bell this afternoon,
All right.
just to make sure it gets reported correctly to the jail. It may or may not be an issue. I just wanted to anticipate that.
All right, well, why don't you go ahead and send that to us? If you could get it to me as quickly as possible, we can get that entered to begin the process of processing them out.
Yes, Your Honor. Thank you.
Unless there are other matters holding them in custody.
There are not.
Next is Ms. Meissner. Are you aware of the charges pending against you?
Yes, Your Honor.
And Mr. Bennett is your lawyer?
Yes.
You understand that Mr. Bennett is also representing Ms. Bogish?
Yes.
And you have no issue with that?
No.
Counsel, are you waiving formal arraignment?
We are, Your Honor.
What was the other number? 35. There it is. And will you need to modify the order for Ms. Meissner in the same way?
I have, Your Honor, and I just need to get Ms. Bell's email address, and I'll send it to her in 10 seconds. Put it on a sticky for me. Thank you.
Do you have business cards, Ms. Bell? Could you please go get them? Could you hold those chains still for me, please?
I'm sorry.
All right, and you're waiving formal arraignment for Ms. Meissner?
Yes, Your Honor.
Right? For both of you ladies, I am moving your case along to a final plea hearing to occur not later than June 30th of 2024. That date will represent your last opportunity to tender negotiated pleas if you wish to do so. Neither of you is required to plead guilty. If it is your desire to maintain your innocence, you may do that, and I will be so advised by your attorneys. And I'm happy to move your case along to trial, but I will not accept a negotiated plea barring extraordinary circumstances after the date the court has provided. Do you understand, Ms. Bogish?
Yes, Your Honor.
Any questions regarding next steps?
No, Your Honor.
Mr. Bennett, anything on her behalf?
Not at this time, Your Honor.
Mr. Fowler?
Arraignment packets for both Ms. Bogish and Ms. Meissner have been provided to counsel. Outside of that, nothing further from the state, Your Honor.
Thank you. Ms. Meissner, do you understand?
Yes.
Do you have any questions regarding next steps?
No.
Mr. Bennett, anything on her behalf?
Not at this time, Your Honor.
Right. All right. Upon the court's receipt of the consent bond orders, the court expects that they will be authorized and transmitted to the jail. So hopefully they will be able to get you processed out at some point today. All right. Thank you. You all may be excused.
Thank you, Your Honor.
All right, Ms. Harrison, I'm ready for the updates.
Yes, Judge. In terms of, I have a total of 8 people who applied today for public defender services. Of those, Judge, Miss Jack Beeman does qualify for services. And Miss Brooke Cotermanche does qualify for services.
Last name again?
Courtemanche.
All right.
And then Maggie Gates, who is position 15 on my calendar, has already qualified for services.
All right.
And then Spencer Liberto, who I believe is position 32 on the court's calendar, has qualified.
All right.
And then Mattia, M-A-T-T-I-A, Looney, who is position 33, I believe, has qualified for services.
All right.
And then I do not have the position, but Arian Robinson has qualified for services.
All right.
And then I have 2 outstanding applications that I will get back to the court about.
And I think they are defendant McCarr. Or is McCarr already through the Southern Center? Was he previously qualified?
Defendant McCarr does not qualify, Judge.
All right, so that's the case that the Southern Center is keeping, correct? All right, Mr. Franklin, I think you indicated that. I have Mr. Marciano.
Mr. Marciano had already qualified for services, Judge.
All right, I have Public Defender's Office and Southern Center. Who's responsible for representation in that case?
Currently the Public Defender's Office.
So that won't be a case that will be handled by your office?
We are still recruiting attorneys, so the attorney make themselves available, then yes, we will put them in contact and confirm to be defended if they want.
I don't know that I entirely understand the approach, but okay. If they qualify for the services of a public defender, we've got attorneys through the public defender and conflict system who are prepared to represent them. I'm just trying to understand what we're doing with the Southern Center. I understand the case where the defendant wasn't qualified, but in the other instances, what's the end game?
It's a longer, detailed conversation. I'm not sure if there's a video person that can get to court, aside from knowing that a case this size presents several layers of conflicts, and that would be a difficult task for anyone. At any point, we made ourselves available to protesters in general who want to be paired with counsel, and we are working with others to make sure that third-party attorneys are paid to represent.
Who is the other? You said there were 2, Ms. Harrison. Who are the other 2?
I have Mr. Is it Vasail, V-A-S-S-A-I-L?
Last 2, yes.
And Mr. Zen.
Got it. Was there something you wanted to tell me, Ms. Walker?
Just that we're going to enter appearances, and if they elect not to use our services and go someplace else, they can do a substitution of counsel.
All right. I think that's probably the cleanest way, as we discussed earlier, so that we can move it along, especially since I have the commitment of your office that those appointments will be made by Friday.
They will be going to the office as soon as you release me.
All right. So I believe that there were only 2 defendants who failed to appear for today's calendar, and I simply want to make sure. I will confirm notice and confirm whether the issuance of a bench warrant is appropriate. The 3 defendants I have are positions 31, 49, and 50 on the court's calendars. I'll give you names to ensure that we have the same defendants. First is Dimitri Lenny.
Yes, Your Honor, that's what the state has.
Did we verify notice? All right, it appears that there was no known address that was provided for Mr. Lenny. Did you have an address in your file, Mr. Fowler?
In just a moment, Your Honor, I'm told that we do have one in our file.
Well, do have one in your file. I should ask the question a different way. Was there an address to which notice would have been sent so that he would have been aware that he had this date?
Not that I'm aware of.
Recently. I'm showing that he was booked into the jail on October 30th and released November 1st. I'm sorry, that's wrong. That's Victor Puertas, wrong person. You're talking about Dimitri Lenny, correct? What are his custody dates? Has he not been arrested? All right. So does the state have a good address?
For Lenny, not an exact address at the moment, Your Honor.
All right, so if we don't have an address, the court's practice is to place the case on the inactive docket because there's no defendant before me.
Yes, Your Honor. Understood.
Next is position 49 on my calendar. That is Mr. Puertas, who's in ICE custody. He was booked in on October 30th and bonded out November 1st. Does the state have any information regarding his business before ICE and whether he is likely to be provided for purposes of these proceedings?
We've been in custody with
Or
Immigration
produced?
and Customs Enforcement, and he can be produced here. My understanding, based upon running his criminal history, is that he adjusted to permanent residency this year. And so that's just based upon what's in his GCIC. I can speak to counsel further to get a little more information, but my understanding is he can be provided to, or
Produced.
court, yes.
Who represents Mr. Puertas? Do we know?
Eli Bennett does, who was just here just a moment ago.
All right, Mr. Bennett is gone.
I previously did, Your Honor. It's now currently Elizabeth Nathern.
What's the last name?
Natherne. She's with the
Natherne?
Yes, Your Honor. That's my understanding.
So what are you asking the court to do with Mr. Puertas' case, Mr. Fowler?
We'd ask that the court keep it on the active docket. We can have him produced at the next court hearing, whichever that may be. We'd ask that the court keep it on the active docket.
All right, if you and Ms. Nathern will confer with Ms. Bell to advise how quickly we can get Mr. Puertas produced.
Yes, Your Honor.
I don't want to produce him for the first time for a final plea hearing and want to ensure that he's arraigned as well. And that will need to occur within the next week. Otherwise, I will place it on the inactive docket.
Understood, Your Honor.
The last matter is position 51. This is the defendant who is Ms. Becker's client we have discussed. And so there won't be a warrant issued in this case as of now, pending time for counsel to confer and provide a status update to the court so that I can determine what next steps are appropriate.
I have one more on my calendar, Your Honor.
Who else do you have?
I have Abigail Skapiak.
I think you're right. I remember the name. Let me get to her. OPQRS. You are correct. Position 54. I do have FTA and didn't note bench warrant. All right. Did you make a motion in that case, Mr. Fowler?
I did.
All right. Ms. Bell has confirmed that the notice provided to Ms. Skapiak was good notice. Accordingly, it does not appear that she's been arrested.
No, Your Honor, not
So there's an outstanding, the charges in the indictment are outstanding. And what's the nature of the warrant? Is it a grand jury warrant?
It's racketeering, Your Honor.
Well, is it a grand jury warrant?
Yes, it is.
All right. And do you have a good address for her? All right. Ms. Skapiak has not been arrested. However, she has failed to appear for today's arraignment hearing, and it appears that the notice was proper. As such, the court is going to issue a bench warrant based on her failure to appear. There is no bond to be forfeited. Is there a $50,000 bond noted on the grand jury warrant?
I believe so, Your
All
Honor.
right, so the state will need to withdraw that grand jury warrant and file a separate grand jury warrant that indicates no bond.
Yes, Your Honor. Understood.
And if whoever's responsible for doing that in your office will notify Ms. Bell when it's done, so that we're sure. I'm going to still issue the bench warrant, which means that there will be two warrants pending, the grand jury warrant and the bench warrant. But the grand jury warrant will need to be modified.
I'll ensure that that's done, Your Honor.
Thank you. Anyone else? All right, Ms. Harrison, did you have anything else? Ms. Walker?
Yes, Judge, I have one more update for the court, and that would be Mr. Vassail, Vassail, and he does qualify.
All right. And that's position 57 on my calendar, so last will be Mr. Zen.
Yes, Judge, and I have not received the application yet, but I imagine I will in a minute.
All right.
I have nothing further.
All right. If there is anyone in the courtroom who believe that you had business before the court relative to today's arraignment calendar, but for some reason your name was not called or you were overlooked, please rise to your feet now.
Your Honor, I'm Christopher, Ms. Permich and Ms. Cass. I just had one housekeeping matter. I wanted to clarify, would you like our clients to be present for the hearing on the motion to extend speedy trial at the end of the day?
It won't be a hearing today. It will just be a conversation. The hearing will be scheduled later.
Okay.
So whether you'd like for them to be in the courtroom is entirely up to you.
Okay, thank you, Your Honor.
I just wanted to have a general conversation around scheduling so that the court would have an idea of what we're dealing with. All right, so I have 10 defendants who have filed motions to extend the deadline for the filing of a statutory speedy trial demand, and I currently have one speedy trial demand, I believe, that has been filed. So counsel, if you all want to step up to the first couple of rows so I'm not yelling to the back, I'd appreciate it. And this otherwise concludes the plea and arraignment hearing in connection with the State of Georgia versus Jack Beeman et al.
Your Honor.
You need to talk with them and work with them to get it done. So whoever the paralegal is, find out who you need to reach out to. Whoever reached out to you for the calendar, I assume. I'll find out.
Your Honor, has been just to be excused.
Yes. Mr. Fowler, we typically receive, the court typically receives bench warrants from the district attorney's office. Who will be preparing the warrant for your office?
We will be preparing it, Your Honor. It will probably come from Miss Wanda Bradfield.
All right, and it should be emailed to Ms. Bell. It should not be e-filed. It should be emailed to Ms. Bell so that the court can consider it and file as appropriate. You can file, of course, the grand jury warrant.
Of course.
But the bench warrant should be submitted to the court. And I presume that you are aware of the process for the filing of grand jury warrants since so many of the defendants were here.
Yes, Your
and you
Honor.
know what needs to be done.
I do.
All right.
Judge, I just got the final application for Mr. Zen, and he does qualify.
Thank you. Have you provided that information to Ms. Walker?
Judge, yes, we're in.
Counsel, I need you to take your arm off the bench.
Yes, Judge, and we have an email chain going, so we're in communication.
All right. So by my count, that was, I think, 10 or 11 defendants requiring the services of the public defender's office, excluding the defendant you'll be representing?
Yes, Judge.
All right. And are you all looping Mr. Franklin into those discussions as well?
Judge, informally, Mr. Franklin and I know each other very well, but I can make sure that he is in touch formally for the conversations.
All right. I appreciate it. All right, Ms. Regis, did Ms. Walker leave us?
He did, Your Honor.
All right. She didn't request to be excused, but okay. All right. I just wanted to have a conversation with counsel as it relates to two matters. Where is Mr. Jimenez? Could we see if we can get him? He also didn't request to be excused.
Mr. Jimenez had left for a doctor's appointment. He was under the impression that he had been excused.
I'm not sure why he was under that impression. He didn't ask the court.
I can contact him right now.
All right. For the defense attorneys who are here in connection with the motions to extend the deadline, are all of your clients still present? At least those who would otherwise want to observe and take part in the motion to extend the deadline? Let me ask the question in the negative. Is there anyone whose client isn't present such that we could not proceed? All right. If your clients are here, then bring them in and we can get started. I think I can take this matter up today.
Your Honor, before we get started, Mr. Jimenez has filed a leave of absence or a conflict for this afternoon.
Mr. Jimenez isn't included in this matter, but I'm going to discuss for scheduling purposes Mr. Jimenez's case because Mr. Jimenez was not excused by the court. So he left at his own peril.
Okay.
leave of absence or not, he did request to be excused. If you all have clients that you'd like to come into the courtroom to be heard, to hear this matter, we should do that now. I do want to proceed. It appears that we should otherwise be ready to proceed. The state has filed a response, and I believe all of the motions that were filed were noticed by the court during the arraignment hearing. So a few of you can step up to the defense table if you'd like. Otherwise, you all can take the first 2 rows and we'll deal with it in that way. As we prepare to get started, Mr. Fowler, given the fact that there is already a pending speedy trial demand that will be running soon, I am curious to know what the state's estimate would be as to the length of trial.
For the entire case or just for Mr. Jimenez?
Let's just assume that all of the defendants who filed these motions to extend will be included. I don't know if they will or not. I'll hear your arguments. But let's just assume we're talking 10 to 11.
10 to 11, I would say that the trial would take approximately 2 months.
Right. And a number under 5?
Under 5 defendants, Your Honor?
Yes.
Probably closer to 6 weeks.
All right. And if it's just one?
A month, probably.
All right, I'm going to give counsel an opportunity, that is members of the defense bar in particular, to confirm on yourselves before we get started so that you all can decide if the court needs to hear from everyone in connection with the motion or if there is someone who is able to make the arguments on behalf of the defendants who have filed the motion to extend the statutory speedy deadline. And just by way of organization, the defendants that the court has noted file such motions are as follows. Defendant Kudamanch, Dorsey, Ellis, Cass, Norman, Nottingham, and I'm going to take that up because that one is to be withdrawn, Parsons, Robert Paul, Shen, and Tenenbaum. Mr. Regas, Shen and Tenenbaum have been qualified by the Public Defender's Office, so I don't know if you want to confer with Ms. Harrison to determine which of you would like to represent them for purposes of today's hearing. I don't believe that any of the other defendants are unrepresented. Did I miss anyone? All right. Ms. Benz, I think you indicated that you were withdrawing your request.
Yes, Judge.
All right. I would simply ask you to file a formal notice of withdrawal so that it will track with your client's case. And how long do you need to get that into the court?
I'll get it to you today by 5.
All right. If you'll get that to the court, just file it and provide a courtesy copy to Ms. Bell. I think that's all that I need. Anything else?
I just need to give Ms. Bell's email address.
All right. If you can step up, she'll give you one of her business cards. And if you'll come not across the courtroom, but the opposite way. No, you can come.
Oh,
just walk. Right. All right, did I miss anyone in connection with the motion to extend the deadline for the filing of statutory speedy trial demand? All right. Do you all want to confer among yourselves, or does everyone wish to be heard as it relates to the matter?
Judge, I would ask that
Don't take your mask off, ever.
I would ask that we have maybe 10 minutes to confer amongst ourselves to see if we can have a collective argument.
I'm happy to give you 10 minutes. Thank you, counsel.
Thank you, Judge.
And you're prepared to argue in your client's absence, of course?
I am if I am the one who is chosen to argue.
Well, and I don't mean you necessarily.
Yes.
Let me finish. I don't mean you making the argument, but you intend to stand in and wish to be heard on that matter, even though your client is still at large.
I do, Your Honor.
All right. You want me to take 10 minutes?
Oh, I thought I heard you. My signature back. Oh, I thought that was my copy.
All right, Mr. Fowler, based on the court's review of the speedy trial demand, it runs the end of December. Am I missing something?
No, Your Honor, I agree.
And that puts the court in a bit of a quandary, but I'll work through it.
Understood.
Very well may be that we seat the jury in December and not start the trial until January. I don't know, which is why I'd hope to have a conversation with... Please make sure you have the mask on before you come into the courtroom. That's the point of the exercise.
Yes, Your Honor.
I'd hope to have a conversation with Mr. Jimenez so that we can get on the same page. Since we don't have a lot of time, I presume you all have not spoken about it at all.
No, Your Honor, really nothing at all about it.
All right. I don't remember the lawyer who was reaching out to him. What was her name? Do you remember?
No, Judge.
Can we get all? Are you getting all the consent bond orders?
He was here first.
Counsel?
I'm sorry, Judge.
Don't be sorry. Just make sure it doesn't happen, please.
For lunch? I will, Your Honor. It's easier focusing.
I need to start getting all the warrants. Nope, not like that. You know, I don't want it that way because I've got too much stuff on my desk. You need to put them in a folder so I can keep them separate because there's no telling where they might end up if I just put them on my desk that way. But I think we need to start getting them. I can start getting them signed.
Can you do it in a second position?
I don't think that matters. Because I don't have any real notes.
All right, everybody, we are following the latest to come out of the 61 people arraigned over public safety center protests. This group called the Stop Cop City group, now in front of a judge on criminal charges, facing RICO charges to be exact. You're taking a look at some previous footage that we took here at Atlanta News First. Again, the court is on a 10-minute break, as you can see here from this phone message, as we wanted to outline to you. They will be resuming in 10 minutes, but wanted to hop on here to take you through some of your other top stories that we've been following here at Atlanta News First. And I want to start with this one. This coming out of Cobb County at a Quality Inn hotel. where a hotel clerk, was injured after being shot by a guest. That's according to police. The scene unfolding in Kennesaw inside of this
We're taking a
Quality
10-minute
Inn
recess.
on
That includes
Cobb
the court.
Place. Excuse me, I'm going to lower that volume there for you. On Cobb Place Boulevard, at a Quality Inn in Kennesaw. Investigators tell us that shots were fired around 2 in the morning. The shooter was arrested around 10 a.m., just hours after allegedly returning to his room where he was a guest at the hotel. Right now, the motive behind the shooting, not very clear. Police are investigating and they're asking if you have any information to please contact them as soon as possible. All right, another story that we're following, this one out of Henry County. Right now, the sheriff is pushing for new legislation that could change how worker compensation affects officers. Atlanta News First, Bridget Spencer has more from McDonough.
When an officer is injured in the line of duty, it can cause some major financial setbacks. That's why agencies across Metro Atlanta are looking to change that now. Police departments from all over Metro Atlanta gathered in solidarity at the Henry County Sheriff's Office on Monday. They say there are flaws in the state's workers' compensation program. Sheriff Reginald Scandrett says a Henry County corporal who was recently injured in the line of duty was forced to only receive 2/3 of his pay while he was recovering, putting strain on his family. Officers are pushing for new legislation that can give an injured officer 100% of their pay.
These are not ordinary situations. This is not an ordinary injury, job type of injury that someone could experience, to where workman's comp has really been set up to handle that.
We have to change a paradigm with respect to how we're making sure our officers are taken care of. And our overall objective here is, how can we help you suffer less?
On November 13th, there will be a charity golf tournament to support Corporal Daniel Podsiadly and his family. In Henry County, Bridget Spencer, Atlanta News First.
And again, that compensation would affect injured officers specifically. We're following the latest to come out of that, and we'll have more details, including what all is going into this proposed legislation, on our website, atlantanewsfirst.com. All right, and this is a story we've been following for really quite some time. It's 2 down, 2 more on the run. A second inmate who escaped from a detention center in Macon just last month was caught right here in Atlanta, in Buckhead specifically. 25-year-old Mark Anderson is one of 4 inmates who escaped custody from the jail on October 16th. Anderson was arrested at a Buckhead apartment building last week on Friday. Now, the first of the 4 escaped inmates, 29-year-old Chavis Demario Stokes, was found. 2 other inmates, 52-year-old Joey Fournier and 37-year-old Jennifer Barnwell, remain on the run. If you see them, you are urged to contact 911 and contact authorities. They are actively searching for these escaped inmates. All right, before we get you back out to court, I do want to share this positive story just to put everyone in a good mood. A special honor going out to Atlanta Hawks star Trae Young, who now has his own street in his hometown. How special is that? The Hawks made a pit stop in Norman, Oklahoma yesterday to witness a street dedication for the point guard. Trae Young Drive now runs in front of the city's new state-of-the-art rec center. The Young Family Athletic Center, which also bears Trae's family's name, will open early next year. Right now, the Hawks are on the road. They are planning to take on Oklahoma City Thunder tonight at 8 p.m. So make sure you tune into that. And you know what else you should tune into at 8 p.m.? We have another update for you. Top of the hour headlines, the latest to come out of Metro Atlanta and the stories we've been following on Atlanta News First and Atlanta News First Plus. So make sure at 8 o'clock you're tuning back here. In the meantime, we're going to continue to take you out to the courtroom where the court break right now is about to wrap up, as you can see. And we are continuing to follow the latest of the 61 that are being arraigned today on RICO charges in connection to protests of the Atlanta Public Safety Training Center. We're going to continue to bring that to you. I do believe court resumes here in just a couple minutes, so make sure you don't go anywhere. Stay tuned as we'll continue to bring you live coverage.
If you need to Okay, so we got everybody on his list.
Just tell you that. Sorry.
No, it's okay.
Should be. That I had you put my list in there.
Yeah.
Nice. Mayor's comment? Marcia comment? Wait a second, there's some consent on. Remember he was the one that had, I don't even. I bet.
Are we ready?
Stage ready, Your Honor.
Judge, I just wanted to make a personal request to be excused if I may join the argument with my colleagues. I have a conflict in the Fulton County Juvenile Court at 2 p.m.
Did you file a motion?
I did not.
Well, one of the things that I'm not going to be able to do in a case with 61 defendants is take announcements from lawyers that they're joining. So in the absence of a filed motion, I'm not prepared to agree to it, because if I do it for you, then I'll have to do it for everyone else.
Understood. Thank you.
You're welcome, and you may otherwise be excused. Who are we waiting for? It appears that most of you all are not in the strategy session, so I'm just trying to figure out how much strategizing is going on. Yes.
Earlier, I had a consent order, consent bond order for Mr. Luke Harper. I ran it by Mr. Fowler, and he looked over it and he's okay with it, and I just wanted to present it to Your Honor.
You can present it to my litigation manager. You didn't have to wait for that.
Thank you, Judge. Thank you, Your Honor.
Thank you. All right, so it seemed that half were participating in the strategy session and the other half were not. I wasn't sure where we stood. I agreed to 10 minutes. Are we ready to proceed, or does the court need to grant more time?
Judge, when you say Michael Schwartz for Mr. Carroll, who's not present, I was on the entrance ramp to return to Savannah, where I live, and I got notice that you wanted to discuss the extension to the speedy trial demand deadline.
I thought I indicated to all of the lawyers who were filing them as we went through, if I was notified that there was such a motion filed, that they needed to remain. That those lawyers needed to remain because I indicated I would take it up after I completed the arraignment hearing, so I apologize to you.
Oh, yeah, if the court said that, I just missed it. I'm sorry. When you said excused, we were wrapping up and hitting the road. And I certainly wouldn't have allowed my client to leave because without him here, I'm not sure how I feel about going forward. I will say, this not being on the docket for today, this is a motion hearing that I would like to have witness testimony for. There's a pretty important factual matter to resolve, and so...
What is it?
The issue, there are a couple arguments for why the speedy trial demand...
Yeah, I don't want the arguments. You said that there are a couple of factual issues. What are the factual issues that you believe implicate your ability to be able to proceed today?
There's a factual issue that goes to one argument, and that is that there's a statutory right to 2 terms of court opportunity to make the demand. In this case, we have an indictment...
Sounds like you're making an argument. What's the factual issue?
Factual issue is the...
Because that is incorrect. It depends on the nature of the offense.
It's true. It could be a death penalty case, and you'd have more time. The factual argument is, the factual issue is that the indictment is stamped July 29th, as if it were unsealed and made available to the parties on July 29th. It was not. Notice was not provided. The e-filing system gave no notice at all. The Attorney General's office gave no notice, which isn't required. They don't.
So, counsel, the indictment, the date that controls is the date on which the indictment was filed with the clerk. And the date on which it was filed with the clerk was what?
July 29th is what the indictment reflects.
Is that the date that it was returned?
That I don't know, and that's where there's a factual issue that needs to be resolved.
I'm showing that the indictment was filed on August 29th.
I'm sorry, August 29th, July term of court. That's right. The notice of that indictment was not provided until approximately September 5th. And by notice, I just really mean I read it in the newspaper.
Okay. So the long and short of it is you're not ready to proceed because it sounds like you're arguing. I just wanted to know I still haven't been able to ascertain what the factual issue is. So as it relates to a factual issue, can you tell me what that is?
Yes, the actual notice to the defendant that an indictment existed.
All right. All right. Who was the person who, it's going to take me a while to get all of the names. I think it was you beside Mr. Regas. You asked for the time to confer so that you all could determine if you could consolidate your arguments for presentation to the court.
I did, Judge. And we elected Mr. Schwartz to be our representative to speak to the court, and I think he has identified the issue. I thought the court said that we were just going to have a conversation. I didn't understand it to be a hearing on the motion itself.
I'm not sure why you didn't understand it, because what I asked was whether there was anyone who had an issue proceeding without your clients present. One of the things that will be challenging to me is if I speak English and you all don't understand. That's what I said. And no one indicated that they had an issue. And then you asked for an opportunity to determine if there was a way for you all to confer, to determine if you wanted to make essentially a consolidated argument. That's what I understood.
And I apologize that I misunderstood, Your Honor.
All right, you can take your seat.
And Your Honor, I'm hearing that.
Take your seat as well. Ms. Nix?
Yes, ma'am.
I'm not ma'am.
I am so sorry, Your Honor. Judge Evans.
I have this note from you. Are you requesting to be excused?
Yes, I am.
All right. Do you have anything to contribute to this discussion?
At this time, I do.
All right. You may be excused. All right. I don't know when, if you all are not prepared to proceed, I don't know when the matter will be set down, but I also need some idea from counsel as to how long the argument will take. What does the state anticipate?
The state's argument will take no longer than 10 minutes, Your Honor. 5 probably, to be honest with you.
Judge, I think...
I just need an estimate, counsel. I don't need you to think out loud. I just need an estimate.
15 minutes of witness testimony and 15 minutes of argument for my client individually.
Okay, so that the court understands how we're proceeding, is everyone requesting to be heard separately, or is there going to be one argument that is advanced by all of the defendants who have filed a motion to extend so that the court will understand what I'm dealing with? Do I need to go through each defense attorney to get some gauge of that? Take your seat. Is there anyone else who wishes to be heard separately? I want to make sure you all understand my question. Is there anyone else who wishes to be heard separately aside from, tell me your name?
Michael Schwartz for Francis Carroll.
Aside from Mr. Schwartz. So Mr. Schwartz, as the court understands it, since no one has stood to indicate otherwise, will be the defense attorney advancing the argument on behalf of the defendants who have filed motions to extend the statutory deadline for filing the speedy trial demand. Is that correct? Yes? Yes. Can I hear from the lawyers? Is there anyone for whom that is not the case? And you all have to work with me. I mean, I've tried lots of cases, have presided over quite a number. I've never had one with 61 defendants. And so we'll have to figure out how we can deal with some efficiencies. But when I ask the general question, I will ask the question in the negative so that I can determine where we stand. Do you understand my question? Be seated, counsel. Right here, the one who stood and asked. Do you understand my question?
Yes, Judge, I understand your question.
Got it. Thank you. All right. So, yes.
Your Honor, on second thought now, I'm thinking about the complications. I would like to be heard individually for my clients on this matter.
Okay. Now, what I don't want, and we can certainly consider that, but I don't expect to hear duplicate arguments. Everybody doesn't need to say the same thing to me.
Understood, Your Honor.
So if you argue after whoever has been identified as the representative for the majority of the defendants who filed the motion, what I won't hear are the same arguments made over and over again. Fair enough?
Your Honor, my concern isn't the arguments. I think there may be factual questions that differ as to some of my clients relative to the others.
I can't imagine what they would be since they're all charged in the same indictment and we're talking about a statutory speedy counsel. So what do you anticipate those issues might be? Enlighten me.
If the other clients are pursuing an argument based on when they received actual notice, that my clients may have received notice at a different time. So that may not be our argument. So that would be my concern.
Anyone else?
Question for clarification. Would the court want us to file a motion adopting or essentially stating that we would allow Mr. Schwartz to argue on our behalf?
I don't think that's necessary. We can get that on the record at the beginning of the hearing.
Yes, Your Honor, Judge Hyman. I have not yet filed a motion to extend the deadline. Depending on how this conversation goes, I may or may not. If I do, I would intend to argue individually at any additional points. But if Mr. Schwartz or anyone else ends up making an argument that I don't have anything to add to, I would be happy to, and of course, inform the court that I wouldn't be adding to the argument. Is that clear?
Yes.
Okay, I want to just make sure.
Anyone else?
I'll go ahead. Catherine Bernard for Priscilla Grimm and Amin Chawi. We are in the same position of recognizing that if the argument that the speedy trial right extends to the following term because of notice, that we would then file a motion at that time. And so out of an abundance of caution, I bring that.
You would file what kind of motion?
It would be a motion identifying our right to a speedy trial based on the lack of notice during the term of court in which the indictment was filed.
I'm not following your argument at all, or your statement to the court.
I apologize, and out of an abundance of caution, I did want to speak up, Your Honor. It would be our understanding that if the right to speedy trial exists for an additional term of court based on the lack of notice of the indictment received in the term of court in which it was filed, that would be a right that could be extended any time through this November term of court. And I only bring it up now out of an abundance of caution, as co-counsel did mention.
Have you filed a motion?
No, not at this time, Your Honor.
All right. That was a statement, so I don't think you need anything from the court. Anybody else? All right, so based on the estimates that have been provided, the state has at this point set 5 minutes. I suspect that may differ depending on the arguments that are advanced. Mr. Schwartz, you've indicated to the court 15 minutes of testimony, and then I suspect you'll have some time to argue, want some time to argue. And then I understand some of the other defense attorneys may wish to be heard on matters that have not been argued by you, depending on what those arguments are. I would hope that you all would all know what the arguments are before you report to court. That was the reason that I gave you an opportunity to confer. So no one should be hearing the arguments that Mr. Schwartz will be advancing on behalf of what I understand to be the majority of the defendants who have properly filed motions or a motion to extend the deadline for the filing of a statutory speedy trial demand. You will know what those arguments are before you report back. I simply need to know how many people we're talking about for purposes of space. Some people may be in the courtroom, some of your clients may have to be outside, but this is where we're going to be. This is the courtroom in which we will be working. I'm not going to try to move to a different courtroom every time I have hearings, because for me it's impractical, and I'm not necessarily comfortable in courtrooms that are not this one, because I don't know the nooks and crannies and spaces. So I have security concerns as well, not as it relates to your clients, but just generally. And so this is the courtroom where the proceedings will occur, which is why I had to conduct the plea and arraignment hearings in the fashion that I did today. So I'll have to work through that. To the extent that there has not been a motion filed, then the court will consider any other motions relative to the filing of the speedy trial demands to be untimely. This is the time for us to hear it. And I'm going to try to find an opportunity to get it heard sooner rather than later. The notice will likely be shortened. And so if you have clients who live out of state, that's a matter that you're going to have to work through with your clients, and they'll have to report as directed by the court and when these matters are scheduled. Do I have any time on Thursday? Thursday. I know what we have. My question was, do I have any? All right, the issue for the court is a decision needs to be made, and my calendar is already set through the balance of the year. That's the challenge. And so I don't know at this point when I'm going to be able to hear the motion. I'm back in trial next week. I'm in court the balance of this week. The only option is Wednesday, which is the day before Thanksgiving, which most people, including the court, would like to have away, but it looks like that may be the only option because I am literally in court every day up to Thanksgiving, and then I am back in court after Thanksgiving the following Monday in another trial. So it looks like it's going to have to be Wednesday. So I'm going to have a seat. I'm going to have the hearing on Wednesday, November 22nd, which is the day before Thanksgiving. If you have travel plans, you'll need to stay because there's no other time that the court can hear it. I'll set it down for 9:30 so that hopefully we can get it done at the top of the day and everyone can be excused. Not ideal, but there's no other time. You got it, Ms. Bell?
Yes, yes.
Anything from the state?
Nothing from the state, Your Honor.
Defense?
No, Your Honor, not for Mr. Carroll.
For any of the other defense attorneys in the gallery?
Your Honor, I do just want to clarify what you said earlier about timeliness of motion relative to the speedy trial. So are you saying that any motion would need to get filed today, or?
Yes, it really should have been filed before today.
All right.
So anything filed after today, I won't consider. Anyone else?
Yes, Your Honor. I just wanted to clarify. Will one of my clients is from out of state? Will they be expected at the motion
Yes.
hearing?
Your clients must appear for all noticed hearings of the court. Hearings, unless it's a conference, if your client's present isn't required, you will be advised, but there are very few proceedings that I don't require defendants to appear, so they'll need to be present.
Understood. Thank you.
You were giving the option of waiving their presence today, but that's not my normal course, so they'll need to show up. Anybody else? And let me be clear, if the notice is sent out and your clients don't appear, then I will issue bench warrants, and I'd rather not have to do that, so you all will need to make sure that they show up. So at this point, I think there are 10 motions that have been filed. Let me just count again. Ten motions that have been filed. One of those was withdrawn, so we're down to 9. And as I call the defendant's name, if the attorney would stand so that I'll know what I'm working with, Kudamash, Dorsey, stay on your feet, Ellis, Cass, Norman, Parsons, Robert Paul, Shen, and Tenenbaum. All right. Mr. Robert Paul, has anyone? Yes.
You said Mr. Robert Paul. They are not present.
Is that your client?
That's my client.
All right. The defendant who stood in the back, tell me your name, sir.
Parsons.
You're Mr. Parsons. Was there a speedy trial, a motion filed in your case to extend the deadline?
Yes.
Who filed it? You did?
LaRonda Nix was the attorney who had a conflict.
That I just excused. And that I think Ms. Nix did not withdraw, and so that's one that will need to be heard. Correct?
Yes.
All right. All right. So there are other attorneys that I see or defendants. Is there anyone else who was expecting to be heard in connection with this motion, but your client's name wasn't called? Did you file a motion?
Your Honor, are you talking to me?
I am.
I filed the first motion, I think, and you just didn't say Mr. Carroll.
Right, and that's because I didn't note it on the calendar. You did file a motion?
To extend the speedy trial deadline?
Yes.
Yes, Your Honor.
When was it filed? I don't have it noted. This is position 6.
Before last week. I can tell you.
While he's looking, anyone else?
Judge, I'm also on Mr. Carroll's case. I'm going to go with Mr. Carroll.
October 25th.
All right. Did I miss anyone else? All right. And for all of the other individuals in the gallery, are you all defendants? I see Mr. Samuel. I know you're not. Were you just hanging out to see what happened, counsel? All right. So of those of you who are standing, if you'll continue to stand, are there any other attorneys in the gallery? All right. So you all just observing?
Yes, Your Honor.
Yes, for everybody else?
Your Honor, I do have the waiver completed for my clients Priscilla Grimm and Amin Shawi, as well as the consent bond order for Priscilla Grimm.
All right, can I deal with what I'm dealing with, counsel? My mind's a little sequitur, so when we start getting sidetracked with as many of you as there are, you'll lose me. So I'll come back to that. You can take that up once we've completed this. Is that what you were here for, unrelated to this motion?
Yes, sir.
All right. So of the attorneys who are standing, not including the ones who have filed motions already for your clients, are the ones who are standing here simply to observe, or were there other matters that needed to be addressed with the court?
To observe, Your Honor.
All right, you can take your seat. Thank you.
To observe.
All right, any of the others who are standing just to observe, be seated. All right, the two in the back.
Good afternoon, Your Honor. My name is Tiffany Roberts, and I'm also here on behalf of Southern Center for Human Rights. I just wanted to confirm that I understood the court's instructions with respect to when we are to notify the court of counsel who has been retained for people who have also applied for conflict defenders. For the court's instructions to let the court know no later than Monday.
You can confer with Ms. Harrison. She's taking the lead on that from the Public Defender's Office. And yes, I did provide a deadline of a week. Actually, did I say Monday or Friday?
Judge, I believe you said, I actually do not know what they're referring to my notes.
I thought that I said by the end of the week, because I know that.
Judge, you said Monday at Southern Center, decision needs to be made.
Okay, and I think I understand now. Ms. Walker was making appointments of any conflict defenders by Friday, and I did give the deadline of Monday for the Public Defender's Office with the Conflict Defender's Office and the Southern Center. And the point is to ensure that that all of the defendants have counsel, and we can move the case forward.
Thank you, Your Honor. And my only other announcement was that the courts, we understand that the Attorney General needs the hard drives to him by Friday.
That's correct.
We have been ordered enough to cover all of the defendants, including those represented by the public and conflict defenders. So if attorneys would like to obtain hard drives free of charge, they can obtain them from us at Southern Center.
All right, I'm sure that they appreciate that. Mr. Regis and Ms. Harrison, you all might want to confer to determine if that's something that's available. Do you have them now?
They'll be delivered Wednesday.
All right. All right. I think what needs to happen, so you all can take your seats. I think we've dealt with those matters. I think that's everyone. So for those of you who have the outstanding motions, this is my notice. We will get out printed notice, and notice will be provided to your clients as well, but you are directed to advise them that the court will hear the motion to extend the deadline for the filing of statutory speedy trial demands on Wednesday, the 26th 2nd of November at 9:30 in the morning here in the court. And that is courtroom 4E. And to the extent that there are any additional motions to be considered by the court, those motions shall be filed not later than the close of business, which is 5 p.m. If you file the motion, please make sure that you send a courtesy copy to Ms. Bell, as it sometimes takes the clerk's office a moment to accept the document for filing, and we don't always receive timely notice. And obviously, as I've indicated, the court needs the information because we have limited space. I want to make sure that we can accommodate everyone, and I need to be able to think about how we're going to move forward in an orderly fashion. My last request of counsel is that you all will confer before you are back before the court the Wednesday before Thanksgiving, so that there can be some synergies created relative to arguments. I understand that there may be a couple of attorneys who may want to raise additional arguments, but I don't want to hear a bunch of arguments popping up all over the place. You all should be able to come together, identify the issues, and designate 1 or 2 representatives. I hear from 1 lawyer generally per issue, but if there are specific things that you would like to raise that are particular to your client, obviously the court will not foreclose the opportunity. I would just ask you to be respectful of the nature of the proceeding, of the number of defendants there are, and not make the same arguments over and over again. I'm not deaf, so once it's made the first time, I've heard it. Got it?
Got it.
Yes.
All right. Is there anything else that the court needs to address relative to this particular motion?
Judge, I do have one matter. My client is Robert Paul. I would like clarification from the court. It will be an impossibility to get her here to be heard, to be present for that motion being heard on the 20th. Would the court's advisement that people who, clients who don't appear will be issued bench warrants?
Well, your client is obviously in a different status, but you have been asked to confer with the state and to provide a status report to the court within 2 weeks.
Yes,
that 2 week, may I finish? Or maybe I should let you finish. Go ahead.
We intend to do that, Your Honor, and comply with the court's direction to file the appropriate status.
All right, so the court has indicated that I want a status report within 2 weeks. That 2 weeks is before the date of the hearing, and so who knows what the status is and whether you can get her here or not at this point, so I can't answer your question. We'll have to cross that bridge when we get to it. I don't know. I don't know that you know. I don't know that the state knows at this point, and so once I receive the status report, then we'll determine what the next steps are appropriate. But if you're raising this issue on behalf of your client, I don't know where this puts you, because if your client has immigration issues and the court rules and she's not here, then I don't know that she will be covered. That's just the fact of the matter. So we'll have to deal with that matter individually, but I'm not making any commitments for a defendant who is not present. You're saying it's not because she didn't want to be here. I don't know, because again, I've not heard the arguments. I have credited what both you and the state have argued or presented to the court, but statutory speedy deadlines are not going to extend forever. And if your client isn't here to be tried, then it may just be an impossibility for her as it relates to the statutory speedy. I don't know. So we'll see where we are, but I'm absolutely not making any promises as to the unique circumstances of your client's case.
Yes, Judge.
Anything else?
Yes, sir. Yes, Your Honor. Molly Armour on behalf of Colin Dorsey. Should it come to pass that we decide to not move forward with the motion leading up to this court date and we file a written withdrawal on the docket, would that eviscerate the need for the presence of Mr. Dorsey and counsel?
Yes, but I would need to be provided written notice of withdrawal in advance of the hearing. And again, when you file the pleading, as a general practice, Ms. Bell should receive a courtesy copy so that the court can ensure we're staying on top of the pleadings and are aware that those pleadings have been filed.
Thank you.
But that would otherwise be acceptable.
Thank you.
Anybody else? All right, anything else from the state?
Nothing from the state, Your Honor.
All right, I think that's all the court has. If you all don't have anything more, you may be excused. Thank you.
And Judge Adams, in regards to Ms. Ellis, I provided her a copy of the indictment.
The court is still on the bench. Please leave quietly. Take your conversations outside. I can't hear you, Ms. Harrison.
In regards to her formal arraignment, I provided her a copy of the indictment. We went over the one count that she is alleged to have been in and the one overt act.
Talking about?
Miss Ellis, my client, and so we would say that satisfies our request for formal arraignment, and I just wanted to make the court aware.
You are, all right.
Thank you.
Thank you.